All right, and good evening, everyone. My name is David Helm. I am an attorney here in Michigan, and this is the Michigan Law Show. Tonight, I want to talk a little bit about the new Senate bill that came out, Senate Bill 81, that was proposed in Lansing today, and particularly regarding the comments made by this particular legislator, and I'm not sure who he is, but I'm going to play him here in a second, and take a look at the ramifications of this bill if it was to actually be passed, and answer what I feel is a important question, which is it actually constitutional?
Today, the Michigan Senate met for the first time since the tragic mass shooting at Michigan State University, and Democrats in the Senate acted quickly to introduce legislation requiring universal background check, safe storage laws, and extreme risk protection order laws that can allow guns to be taken from people who judges deem are dangerous to themselves or others. So this is the first step that we need to take here in Michigan to enact common sense gun safety laws. And I'm really hopeful that now that for the first time in 40 years, Democrats are in control of the Michigan legislature, we can move on to action on gun safety.
All right, so that was Senator somebody or House Representative somebody. Anyways, common sense gun safety reform. That's what everyone keeps talking about. Now, if you're one of those individuals that think guns are unnecessary, it doesn't matter what I'm going to say. You're not going to be persuaded. You're going to think that guns are bad and nobody should have them anyways. So why bother talking about the Second Amendment, which is what we're going to be discussing today in contemplation of Senate Bill number 83. But to everyone else, Democrats, Republicans, Libertarians, Independents, everyone else who owns a gun, believes that guns are useful for the citizens to have, this video is for you. And I want to pull up this bill here, and I'm going to talk about it in context with a recent ruling from the Fifth Circuit Federal Court of Appeals out of Texas that talked about something very similar to this. And that decision took its lead from fairly recent U.S. Supreme Court cases that dealt with the right of individuals to possess firearms. But it deals with something very similar. So the reason why I picked Senate Bill 83, there are some other bills we're going to talk about too, but Senate Bill 83 is, I find, the most obnoxious for many reasons. So we're just going to walk through it here. I've highlighted some sections I want to emphasize and see how it stacks up to the scrutiny that very likely will be coming its way if this gets passed. So this bill was introduced today, February 16, 2023. Now, interesting to note, any law that's passed in reaction to some sort of event that's emotional is always going to be bad law. And this is no exception. So this was introduced by Senator McMorrow. Beyer signed, a bunch of individuals signed in on this particular mess of a bill proposal. But the act is called, where is it? Oh, I had it highlighted. The Extreme Risk Protection Order Act. And that's the name of this act. And if it gets passed, that's what it's going to be called, Michigan's Extreme Risk Protection Order Act. And it goes through a few definitions here at the beginning. We have defendant means an individual against whom the Extreme Risk Protection Act is requested in an action under Section 5. And an Extreme Risk Protection Order is an order that's entered in under Section 7. So let's just keep going through, and we're going to get to the meat of this. So Section 5, an individual described in Section 2 may file an action with the circuit court requesting the court to enter an extreme risk protection order. So this is similar to a personal protection order, except this act is specifically designed to remove firearms from individuals, which seems fine. We're going to have a protective order type proceedings that's going to remove firearms from individuals. But we're going to go through this, and hopefully you'll understand why this is a very bad law. An individual who files an action under this section shall do so by filing a summons and a complaint on forms approved by the State Court Administrator's Office as directed by the Supreme Court. The complaint must state facts that show an issuance of an extreme risk protective order is necessary because the defendant poses a significant risk of personal injury to the defendant or others by possessing a firearm. So, what does a significant risk mean? Well, the statute gives some clarity on that. If the plaintiff knows or believes that the defendant owns or possesses a firearm, the plaintiff shall state and identify the firearms in the complaint. Okay, so that's just if you know of a particular firearm. Where are we getting down to the definitions? Here we go. Section 7, this is where the meat starts. In an action under Section 5, the court shall issue an extreme risk protection order if the court determines by the preponderance of evidence that the defendant poses a significant risk of personal injury to the defendant or others by possessing a firearm. Now, preponderance of the evidence is the lowest form of standard that we have of anything. It is simply, is it possible? Is it likely? We're talking about here. This is the preponderance of the evidence. This is the lowest standard of proof. It is used primarily in civil proceedings. The standard means that it is more likely than not that the facts are as which one of the parties claims. So is it more likely than not? That's the issue. Is it more likely than not that this person poses a significant risk of personal injury to the defendant and others by possessing a firearm? Okay. Well, what does that look like? We can always think of the extreme situations. A guy with mental health issues that are documented, talking about him seeing Abraham Lincoln and firing his gun in the air, trying to kill Abraham Lincoln. All right, there's an extreme situation. It's probably not the most likely situation, though. In making its determination under this subsection, the court shall consider all of the following. All right, this is what the court's going to consider. A history of use, attempted use, or threatened use of physical force by the defendant against another individual or against the defendant, regardless of whether the violence or threat or violence involved the firearm. So a threat of violence. By the way, these are not and. You don't have to have threat of violence and the next thing. This is just that. A threat of violence. What's a threat of violence? If you post a picture of your firearm on social media and you say, this is going to make all the liberals cry, is that a threat of violence? Any evidence of the defendant being seriously mentally ill. By the way, we already have a provision regarding serious mental illness and protective orders and things like that. So we don't need a statute to identify subsection B here. Any provision or any previous or existing extreme risk protection orders. Okay, so it assumes the existence of one in the past. Any violation of the defendant of a previous or existing extreme risk protection order issued under this act. So whether a previous order was in place or whether a previous order was in place and that the defendant violated it. Any violation by the defendant of a previous or existing personal protection order. Any previous conviction of the defendant for any of the following. Misdemeanor violation of section penal code. I'm assuming these are assaultive behaviors. I didn't look them up. Domestic violence. An offense involving cruelty or abuse of animals, which You could get that, I guess, if you're pulling your dog too hard on a leash. But apparently, that's one of the offenses that they're going to take your guns away. Any evidence of recent unlawful use of controlled substance by the defendant. So, completely unrelated to a gun, no physical threats, no assaultive conduct. If you have used a controlled substance in an unlawful manner, they can take your gun. Any previous unlawful and reckless use, display, or brandishing of a deadly weapon by the defendant. Display or brandishing. So, brandishing is when you're carrying the weapon on you and you're showing it to others, pulling it out and showing it around. That's brandishing. Display is distinctly set apart from that. So, does display mean hanging it up on your wall? Does it mean taking a picture of it and posting it on social media? And I highlighted this next section in red. Any evidence of an acquisition or attempted acquisition within the previous 180 days by the defendant of a deadly weapon or ammunition. The mere act of purchasing or attempting to purchase a firearm could have all of your firearms seized. Think about that. It doesn't say that it needs to be connected with a threat. It doesn't say that it needs to be connected with a assaultive conduct, that you're possessing this gun while under the influence of a controlled substance unlawfully, or generally. It doesn't say connected to brandishing it. The attempted purchase or the purchase within 180 days of a deadly weapon or ammunition could be justification under this law to have all of your guns seized. Buying a gun denotes losing all of your guns. That's what this says. Any actual information the court finds to be reliable, including a statement by the defendant or relevant information from a family or household member concerning the defendant. Any additional information that the court finds reliable, not relevant to whether or not he poses a safety threat. Any other fact that the court believes is relevant. So, if you're using controlled substances unlawfully, if you are purchasing a gun or purchasing ammunition, if you are displaying a firearm, if you've been cruel to animals, any of these things that are not at all connected to firearms could authorize the court to issue this extreme protective order, or any other facts, really. The court in action under Section 5 may issue an extreme risk protection order without written or oral notice to the defendant. So, the court's going to review all these things based off of the plaintiff's petition, or rather complaint, judged by the preponderance of the evidence, without the defendant having any say, and can order an extreme risk protection order. Can just sign it. The restrained individual may file one motion to modify or rescind the order during the time the order is in effect under Section 9(1)(I), and one motion to modify and rescind the extended order during the time the extended order is in effect under Section 17 or 19. If the restrained individual files more than one motion during the time described, the court shall review the motion, but then simply dismiss it. Summarily dismiss. Why even have the court review it? It's just going to be summarily dismissed. This is killing me. At a hearing on a motion under Section 4, the individual restrained under the extreme risk protection order must prove by the preponderance of the evidence that the restrained individual does not pose a significant risk of personal injury to the restrained individual or others by possessing a firearm. So, let me just get this straight. You can have this order imposed upon you for a myriad of reasons, one including just purchasing a gun. Then the court can order it. Then you have one chance to modify it. And during your hearing to modify or terminate this order, the burden is on you to prove that you are not a danger to yourself or others. They shifted the burden. Now, on a personal protection order, for example, if the individual comes to the court on a personal protection order, they must prove by clear and convincing evidence that the person is a danger to others, particularly to the person that's requesting the order. Then, if the person who the order is imposed upon files a motion to terminate or modify the PPO, the plaintiff still has the burden to prove why it should still be imposed. The burden doesn't shift in a PPO. The burden shifts here. Now you have to prove your innocence. Nowhere in this country have we had to prove innocence before, especially given this type of situation. If the court determines under Section 7 that an extreme risk protection order should be issued, the court shall include all the following: that the restrained individual shall not purchase or possess a firearm, and surrender a license if he has a personal protection, or CCW. Mind you, it doesn't say don't come in contact with the petitioner, don't harm yourself. It just says turn over all your guns. That the person shall not apply for a concealed pistol license. Surrender all firearms in the individual's possession or control to a law enforcement agency designated under this subdivision. So basically, what you got to do, and we'll get to it a little bit later, but within 24 hours, you need to contact your local police department and say, come take all my guns. You can't give them to somebody else. You can't do anything else with them. You have to call the police on yourself and tell them to come take all your guns. The order also is supposed to tell you that you have your one time to file a motion to withdraw this order. What is this? The court must also tell the person that a violation of this order will subject the individual to immediate arrest and contempt powers under the court to be sent to prison for up to 93 days. Now, this order expires automatically within 1 year, but you'll see that there's a provision for extending it for another year. And again, the burden is preponderance of the evidence. Very low threshold. So, not later than within 24 hours after the extreme risk protection order is issued, the restrained individual may do either of the following: file with the court, that issued the order one or more proofs of relinquishment or removal. So basically, within 24 hours, not only do you have to call the police and have them come take your guns, then you have to go file with the court proof that you have relinquished all your guns. It's not on the court officer to do it or anything like that. There's no burden on the plaintiff to follow up with anything. The burden all shifts 100% to the person who purchased a gun and is now being required to turn over his guns. If a restrained individual has not satisfied the requirements of subsection 1A or B within 24 hours after the extreme risk protection order was issued, the clerk of the court shall issue or shall inform the local law enforcement agency designated under the section, your local law, your police department, of that fact. The law enforcement then shall make good faith efforts. You know what that means? They're going to be coming over to your house, kicking in your door, and taking all your guns. At any time while an extreme risk protection order is in effect, the plaintiff or a law enforcement officer may file an affidavit with the court that issued the order alleging that the restrained individual has a firearm or a concealed pistol license in the individual's possession or control. So, this is an allegation of you violating this. Now, get this. If an affidavit is filed under this section, the court shall determine whether probable cause exists to believe that the restrained individual has a firearm or concealed pistol license in the individual's possession or control. Probable cause. Probable cause. Oh my God. Probable cause. Where's my statute? Oh, where's my case? Probable cause, been defined by the Supreme Court of the United States, is a practical, non-technical conception in dealing with probable cause. As its very name implies, the court deals with probabilities. This is not technical. They are the factual and practical considerations of everyday life in which reasonable and prudent men, not legal technicians, act. The so-called two-prong test suggests that the two prongs be intended simply as guidelines to a magistrate's determination of probable cause, not as inflexible, independent requirements applicable in every case. It requires only that the magistrate must be informed of some of the underlying circumstances, from which the informant concluded, in this particular case, that narcotics were where he claimed they were. That's written weird. And some of the underlying circumstances from which the officer concluded that the informant was credible or his information reliable. It's a very low threshold. It's an extremely low threshold. It is the lowest threshold. This is what we need to charge somebody with a crime. The court finds that probable cause exists. The court shall find the restrained individual in contempt of court and issue an arrest warrant on probable cause. This is, I don't know if this is done with my analysis. I think this is a horribly written law. Just going back up to these standards. Well, first of all, shifting the burden onto the defendant. We're going to presume you guilty until you prove yourself innocent. That's what this is saying. Mind you, this isn't like after you've been convicted of a crime and you're on probation and the threshold is really low or something else. This is at the onset. This is your one bite at the apple to defend yourself. The burden is on you. You're guilty until you prove yourself innocent. Guilty of what? Any evidence of an acquisition or attempted acquisition within the previous 180 days by the defendant of a deadly weapon or ammunition. That's it. Someone has to file a complaint saying, I saw him acquiring a deadly weapon within the last 180 days. This isn't in connection with something dangerous. This is just period. In an action under Section 5, the court shall issue an extreme risk protection order if the court determines by the preponderance of the evidence that the defendant poses a significant risk of the injury to the defendant or others by possessing a firearm. Okay? In making this determination under this subsection, the court shall consider all of the following. I don't like this law. Now, I want to talk about it in context of this case here. This is United States of America versus Zachary Ramey. It was issued just this year, actually, February 2nd, 2023. And I'm not going to go into a very extensive review of this case. I would turn to uncivil law. I would recommend uncivil law for a very thorough analysis of this case. I'll put a link to his YouTube channel, but he went over this when it first was issued, or actually maybe just a couple weeks ago. But so the underlying question in this, the court phrases, the question presented in this case is not whether prohibiting the possession of a firearm by someone subject to a domestic violence restraining order is a laudable public goal or policy goal, rather. So this is very similar. This is a domestic violence restraining order. And the court's saying here, we're not saying, the question is not whether or not prohibiting somebody from having a firearm should be a public policy goal or whether or not it's a good public policy goal. It says the question is whether 18 USC 922 G8, a specific statute that does so, is constitutional under the Second Amendment of the United States. Now, I have pulled up the statute. This is the particular section here. And go back up to G. It shall be unlawful for any person to do what? Who is subject to a court order that was issued after a hearing on which such person received actual notice and at which such person had an opportunity to participate, restrain such person from harassing, stalking, or threatening or intimidating an intimate partner of such person or child of such intimate partner or person, or engage in other conduct that would place an immediate or an intimate partner in reasonable fear of bodily injury or a partner or child, and includes a finding that such person represents a credible threat to the physical safety of such intimate partner or child, or by its terms explicitly prohibits the use, attempted use, threatening use of physical force against such intimate partner or child that would reasonably be expected to cause bodily harm or bodily injury, rather, or convicted of a misdemeanor of domestic violence and a whole bunch of other stuff. But basically what this does, so this is the section that they're referring to. So this is a PPO. This is a personal protection order. Now, a personal protection order, what this law is saying is that someone who has been subject to a personal protection order, a domestic personal protection order in this case, is prohibited from owning a firearm that's gone through interstate commerce. This is a federal statute. And a personal protection order, much like this extreme safety, whatever bullshit they call it, Extreme Risk Protection Order Act, much like that, what you're doing is you're putting a prior restraint on somebody. They haven't been convicted of anything. They haven't been alleged to violate a crime. They're saying it's possible that you could commit a crime, and therefore we're going to restrain you prior to you actually doing something. It's taken in that context, this court, the Fifth Circuit Court, by the way, Federal Circuit Court, is analyzing this federal statute to see if it's violates the Second Amendment to the Constitution. Now, if it violates the Second Amendment to the Constitution, then my position would be that House Bill, or rather Senate Bill 83, also violates the Second Amendment to the Constitution. And again, I'm not going to get into all the details on this. I'll put a link to Uncivil Law's review of this case in the description so you guys can find it later. It's not there now. But Zachary Rhyme. Now, here's the other thing, too. They make no bones about it. This is a bad guy. Zachary levies his facial challenge on 922 G8. The district court in the prior panel upheld the statute, applying the court's pre-Burham precedent. So if you guys recall, not that long ago, how long ago? Let me see here. Oh, let's see this. New York State Rifle and Pistol Association versus Brown. This was decided last year, June 23rd, 2022. So basically what had happened is this case was pending. It went to the district court, and then it went to the Court of Appeals, the Fifth Circuit Court of Appeals. But then this case was issued, and now in light of this case, they're taking another look at Zachary's case. And the court does a wonderful analysis of why they ultimately find. I'm going to scroll down. I'm going to spoil this for everybody. Therefore, the statute is unconstitutional. So, but Brian, so I'll just do this. Doubtless that 18 USC 922 G8 embodies Salisbury policy goals meant to protect vulnerable people in our society. Weighing those policy goals merits thorough and merits through the through the sort of means end scrutiny. Do the ends justify the means? That's what they're talking about here. And talking about the prior precedent. However, under the Braun case, that analysis is no longer appropriate. The analysis is whether or not there is a historical analog to this type of action. Basically, what they're saying is at the time the Constitution was written, could the founders have foreseen a situation, and would they have found it acceptable to foresee a situation where we have a prior restraint on an individual? Remember, he's committed no crime. This is a prior restraint. So was that contemplated at the time of the framing, at the time the Constitution was created and the Bill of Rights were implemented? Could the founders have foreseen, is there any sort of analog where a prior restraint would justify the removal of someone's Second Amendment rights? And this court said, through that lens, we conclude that 922 G8's ban on possession of firearms is an outlier that our ancestors would never have accepted. Therefore, the statute is unconstitutional. So that is what I would think would be happening to this bill if it was to pass. Now, I'm going to talk about some other bills. Senate Bill 83 is absolutely horrible, but it gets even worse. This is Senate Bill 76. Again, it was introduced yesterday. And again, I will reiterate that bills passed in the wake of things such as the MSU shooting and otherwise make for horrible law. So this is an amendment to an already existing statute. It says, except as otherwise provided in this act, a person shall not purchase, carry, possess, or transport a firearm in the state without first having obtained a license for the firearm as prescribed in this section. Did you notice what was changed there? They struck pistol and they imposed the word firearm. And they do that throughout this, and they do that throughout many, many, many statutes. This is one. No, sorry, that's a new one. There's another statute too where they do that too. So it used to be required, or it still is actually required now in Michigan, that you obtain a license to purchase a pistol or a handgun. But a long rifle, a shotgun, a hunting rifle, or anything else, you didn't need a license for, because we're a hunting state. People hunt in this state. And but this amendment makes it a license required. Every firearm, even rifles and shotguns, need to be you need to get a license for. So that's what this bill does. Now this is Senate Bill number 78. This one is concerning as well. This was introduced today, February 16th. Did I say yesterday earlier? Today's the 16th. An individual who stores or leaves a firearm unattended on premises under the individual's control and who knows or reasonably knows that the firearm is accessible to a minor shall do one or more of the following. Store the firearm in a locked box or container. Keep the firearm unloaded and lock the firearm with a locking device that is properly engaged to render the firearm inoperable by any individual other than the owner or an authorized user. Subsection 2 here talks about any individual who enters the premises of another. So you have a guest come over and the guest has a gun. The guest has to do the same thing with their gun if there's minor children in the house, I guess. It talks about or leaving it in a locked compartment in their vehicle and things like that. The problem I have with this is that I think it flies in the face of this case. I also think it flies in the face of this case. And I think it flies in the face of Heller, which is the starting ground for a lot of these recent Second Amendment cases. All these cases say lawful firearm in the home operable for the purposes of immediate self-defense violates the Second Amendment. See that? Court held that the district's ban on handgun possession in the home, right there. That's this case. This is big case Heller, which is the first time that the court actually started treating the Second Amendment like any other right. You don't have this kind of scrutiny for First Amendment rights, the right to religion. You only have this type of scrutiny that people scrutinize the right to keep and bear arms. It only applies to the Second Amendment. This is the first time where the Supreme Court has actually started to say, hey, this Second Amendment is just as important as all the other amendments, all the other rights contained in the Constitution. This one's just as important. And it held so that the court held that the district's ban on handgun possession in the home and its prohibition against rendering any lawful firearm in the home operable for the purposes of immediate self-defense violated the Second Amendment. Where is it? Hang on. Oh, I forgot I scrolled down past my highlights. All right. Storing the firearm in a locked box or container. Keep the firearm unloaded and locked. And lock the firearm with a locking device that is properly engaged to render the firearm inoperable by an individual other than the owner or an authorized user. I would say that renders a lawfully owned firearm in a home unoperable for the purposes of immediate self-defense. These new laws, while they sound good, while they make you feel warm and fuzzy on the inside, especially for those people that don't own guns and can't see possibly the need for one, yet they run to the police who all have guns. These new laws might sound good, but they are doing, they're simply unconstitutional, and they're not going to solve the problem because people who want to commit these acts are not concerned about making sure their gun is in a proper locked container, or that their rifle is now registered, or that there's a restraining order against them, an extreme risk protection order against them. People who want to do harm aren't going to care about these things. All that's going to do is affect the individuals that are law-abiding, that follow these laws, these ridiculous laws, that are going to be, actually, if you go back to, let me find it here. Oh, which one is it? Oh, this here. Yeah, so you have to get a license to carry any firearm. It actually makes a requirement in here, too, that you have to get a license if you're bringing the firearm in from another state. So if you live in Ohio and you want to come to Michigan for hunting, you got to get a license. It's somewhere in here. I didn't highlight it because I didn't think it was relevant to my conversation. Older, if the firearm is a pistol, then the seller is licensed. It's somewhere in here. Anyways, it's nonsense. If you own a firearm, I don't care what party you're in. If you own a firearm and you like the right to use that firearm, to keep that firearm for your personal protection, for whatever reasons you want to lawfully use that firearm for, contact your state legislators, contact your House of Representatives members, contact your state senator, and tell them to completely forget about these bills. Again, you know what? Let me pull it up this way. I'm going to show you guys something. Michigan House bill. All right, let me share my screen because it's important that everyone knows where to find. I got to do this. Where to find this legislation. Okay. Let me pull it up this way. Okay. Michigan legislators' bills. All right. So this is the Michigan legislators' website. You can search by specific bill number. You can search by category. You can search by daily. You can click right here and figure out all the bills that they passed today. Or not passed, sorry, rather introduced today. You can also find past bills, but they didn't pass anything today. You can type in February 15th and find all the bills that were introduced yesterday. So we're going to go back to the 16th here. And these are all the bills that they introduced. And we have, let's see here, 76. Weapons and firearm license, background checks to purchase firearms required. This, I didn't even go into this one. This one's stupid too. Basically, if your dad wants to give you a gun, he's got to do a background check on you. 77. We have 78, 79, all the way down. All of these. Tax exemption from firearm safety devices. Basically, you get to buy them free of sales tax. All these bills. Call your legislators, call your representatives in the House, call your state senators, and tell them to forget about this, to vote no on this. I can't remember where they were assigned. Let's see here. Bill document. Oh, yeah, by the way, so you could click on this, and then you could see the sponsors of the bills. You could see who sponsored them, what district they're in. The categories are weapons, firearms, law enforcement, that sort of thing. Here's the bill document itself. Now, as this goes through, there's going to be, as passed by the Senate, as passed by the House, there's going to be other category. Oh, here's bill analysis. They don't have any yet. So, but there'll be popped up some other analysis because they're going to go through committees, and the committees are going to say, this is how it would change, and this is the good, and this is the bad, and this is what people are saying. The bill analysis will end up there eventually. So you can find all that stuff here. Keep an eye on it. I would contact these individuals. I doubt they're going to do anything about it, but tell them you're unhappy about it. And again, contact your legislators and tell them to forget about this and vote no on it. It's just a really bad law. It's made in the heat of emotions, and it's unconstitutional. It's going to take people like me and other attorneys fighting this thing. As soon as it gets passed, there's going to be 100 lawsuits filed against it and hold that it's unconstitutional, especially in light of what the U.S. Supreme Court has been doing, particularly in light of what the Fifth Circuit Court of Appeals just did. I don't think these laws are good. I don't think these laws are constitutional. They shouldn't make it beyond today being introduced. They should die in committee, and hopefully that will happen. Okay, that's it for today. I've been talking long enough. Hopefully you guys got something out of it. I will be back tomorrow with a review on the Crumley Parents case. We're going to give an update on what's been going on lately. We have Court of Appeals. When is it? March 6th. Or no, sorry, March 7th. Court of Appeals arguments March 7th on the Crumley Parents. So I'm going to try to stream that live. I was talking to the Court of Appeals clerk today, making sure that got all arranged. And other than that, I will see you guys tomorrow.